Thank you. So I was asked to present on Indigenous-led Rights-based Approaches to Climate Litigation. The Torres Strait 8 and the Pabai versus the Commonwealth of Australia, which its findings has just come out and they're being contested to go again. So an interesting case, but I'll touch on these two cases. Before I start, I would love to get to this second paragraph, but I would first acknowledge the traditional custodians of this lands where I join, the Turrbal and Yagara people, and I pay respects to elders both past, present and emerging Indigenous leaders, and extend respect to other Aboriginal and Torres Strait Islander people that may be listening to this recording, but also present in this room. I acknowledge the traditional custodians of this land and their care for it for thousands of years. I recognise that others came to this country. There was violence and injustice. We gather on this land we now share, aware of the past injustices, and with the respect for the land and its ancient peoples. Open to the spirit who has been present here, we resolve to continue to appreciate its beauty, to protect its resources, and to honour the connection that traditional custodians have to this land. I acknowledge these lands have never been ceded. So who am I? I want to begin by the following my own cultural protocols, by introducing myself and where I speak from. I speak today as an initiated Torres Strait Islander man carrying cultural responsibilities passed down through my family and community. Minikineso Karamin Ngayapa. Ngai ka yamon ngitimun pa keda ngaunel Francis Nona ngai ait kadal malubaidam. Ngau totums, ngau clan, Debao clan. What I say to you in my language is kalau kawau ya. Is I say where I am, where my traditional homeland is in Torres Straits. My clan is the Debao clan. My totems is the ait kadal malubaidam. That's the crocodile and the shark. And I tell you this because I'm drawing from Indigenous knowledges connected to place. I also speak as a registered nurse, someone trained in Western systems of health, caring for patients and communities. And I speak as a researcher working in public health to better understand how climate change impacts health and how we can respond. These three identities intersect every day of my life. I walk in two knowledge systems and two cultures, Indigenous and Western, and I see the strength that comes from holding both. It is from this place that I share my words with you today. What are you looking at on this map? In Western sense, it's not the states and territories. It represents more than 65,000 years of law, kingship, custodianship and inherited knowledge systems. Each area reflects a living country with its own language, stories, obligations, seasons, governance, medicines, and relationships with neighbouring countries. This is a map of continuity, a map of sovereign societies whose governance structures didn't disappear with colonisation, even though they were denied, suppressed and often violently disrupted. For many Aboriginal and Torres Strait Islander people, country is not a backdrop to life. It is life. It is the identity, body, law, memory and future. It is relationship of care and reciprocity. Country watches over people and people watch over country. Australia was not an empty land waiting for development. It is already governed place, an interconnected cultural landscape shaped by tens of thousands of years, an ecological and legal stewardship. So I would frame this worldview as ecological centric. I will shape this worldview as ego-logical centric, to dominate, to sit in a hierarchy of systems. This map of mining operations in Australia, as of December 2024, it's a visualisation of another form of governance, a particular culture and a way of seeing land, where Indigenous people showed a living networks of countries, Languages, kingship systems and obligation. In this map, land is resource. A grid of extractive opportunities. Country on this map is reduced to mineral deposits, licenses, tenure and profits. Every dot here represents not just an industry, but a decision-making system that places extraction and profit above care. Economic growth above cultural continuity, and short-term monetary gain above intergenerational health. For Aboriginal and Torres Strait Islander people, these dots represent disruptions to country, water and food systems, law, story and ceremony. These operations carry real health consequences in the body, in community and across generations. So this map doesn't just show where mining occurs, it shows how a settler colonial state imagines land as something to be owned, carved up, dug up and regulated. In contrast, the previous map reminds us that country is not just land in the Western sense, it's a relation, a responsibility, a living ancestor. The tensions between these two maps is the tension at the heart of climate justice in this country, and it is the space where health law, culture and governance collide. The worldviews of legal structures that privilege one map over the other is merely one way to look at the current situation, as I'm about to unpack. Zenadkes the place, known as Torres Straits. I am from this place. One of the cases that I will show, the two cases that I will show have come out of this place. This place, known in English, is Torres Strait Islands. Our islands sit at the very top of Queensland between the tip of Cape York and the southern shores of Papua New Guinea. The region stretches across 48,000 square kilometres of open sea, with more than 90% of it being ocean. This vast sea country is at the heart of who we are as Torres Strait Islander people. The sea provides food and resources through hunting and fishing, sustaining our families and communities. But it also sustains our identity. Sea country connects us to spirituality, physically, grounding us in culture, ceremony and belonging. Our identity is deeply maritime. Our stories, ceremonies and livelihoods are tied up in the tides, the winds and the stars. But these same elements are now shifting. Rising seas, eroding shorelines, changing fish patterns and increasingly unpredictable weathers all threaten the continuity of life as we know it for generations. So when we talk about climate change, for us it's not abstract. It's happening now in real time. In a developed country, we could be the first asylum seekers. So when we talk about fighting in the court systems, what are we fighting for? What does it mean to who? What do we deem as evidence? Connection to place. So in Zenadkes, adaptation is not new. Our ancestors always have adapted to tides, to trade, to colonisation. But the pace and scale of climate change are testing the limits of what adaptation can mean. Houses are flooding during king tides. Ancestral burial grounds are being washed away, and community infrastructure is under strain. In the absence of government action and support, communities are finding their own small-scale solutions. These impacts of these changes, not just physical, they are also cultural and spiritual, threatening language, continuity, place-based knowledge, and social cohesion. The island on the left is the island I grew up on, Pabai Island, which is at the top of Zenadkes. The case that is going through the courts now, one of the plaintiffs is from this island. What we are seeing on our lands are not showing on our televisions as I work here in Meanjin. I'm not seeing what I feel connection to place. Who gets to govern that? How we are not aware of this? As cargo boats come in, we take pallets to hold our shores so our houses don't get eroded. Whose mindset is governing these systems on what's best for when we think of community? I want to go back and pause to think about a case that went through the court systems here in Australia in '94. For us Indigenous people, it is important to acknowledge the past and pay respect to those whose footprints we walk in. For this, I want to acknowledge Uncle Eddie Koiki Mabo and plaintiffs who took the Queensland Government to court to recognise customary law, our pre-colonial law, and therefore to recognise Indigenous land rights. The Mabo case in '92 was a landmark case. It was one of the first time European law recognised customary law. This case overturned the myth of terra nullius and unfroze Australian law from its racist beginning. This has since laid the legal path for native title for our mob to continue to fight for our connection to lands and waters. As Indigenous people, history matters to us, remembering what our ancestors fought for as part of our cultural ways. So I acknowledge this case, given the people's leadership and shift in common law decades ago. When I talk about history, it's the past of what we've walked through. When we think about our common law, there are two animals that sit on our emblem. Those animals are an emu and a kangaroo. Why are they there? They are there because they can't go backwards. And when we think about policies, when we think about decision making, it's not to draw from. So here we have this conflict of First Nations people who situate themselves through 65,000 years worth of knowledge, and we have a system that only thinks about what is in front of us. And the collide begins. And where does the fight finish? In courts. The latest IPCC report confirms that many of us already know. Climate change is a human-driven and threatening the health of humans and more than human world. But recent evidence also highlights a deep injustice. First Nations people contribute to the least of global emissions, yet we are among those most vulnerable to its impacts. Around the world, Indigenous communities are not standing still in the face of this crisis, as we saw in the previous presentation. Alongside scientists, lawyers and civil society, we are demanding urgent mitigation and adaptation. Increasingly, this work is being taken into the courts. Climate litigation now spans a wide range of approaches. From human rights cases to environmental planning and impact assessments to holding corporations accountable. Globally, the number of climate-related cases has more than doubled just in 3 years. Importantly, Indigenous people are not only participants in this movement, we are leading it by taking governments and companies to court. We are using the law as a platform to push for justice, to reform policy and governance, and to protect the right to remain on our lands and our seas. I go back to the comment, in time to come, in a developed country, Zenatkas people could be the first asylum seekers in a developed country. So climate litigation movement in Zenatkas, there's been 2 cases that have come out, 3 cases have fought the courts, but in recent times the 2 are around climate litigation. We had native title, Eddie Koiki Mabo. So in Torres Strait, the movement has taken 2 landmark forms. The first was the United Nations Human Rights Committee case brought in 2019 by 8 islanders, including Daniel Billy, which found that Australian inaction on climate change violated the rights to family, culture and home. Again, let's go back to those world views. What is important for who? So here we have First Nations people fighting for the rights to family, culture and home. Under the United Nations Declarations for Indigenous People, we have to give right to those 3 things and many more. Practice culture. The second is the Pabai and Guy Paul Kabai case, brought before the Federal Courts of Australia. Here, 2 traditional owners from the islands of Boigu and Pabai argued that the Australian government owes a duty of care to protect Torres Strait Islanders from climate harm. The case takes the struggle for justice from the international stage back into the hearts of Australia's legal system, asking whether domestic law is capable of recognising its responsibility to First Nations communities on the front line of climate change. Together, these cases show that Indigenous law and knowledge are not only resisting loss, they are transforming the very systems that once excluded them. I want us to offer some reflection on what this movement might be teaching us. First, we see courts start to recognise the depth of labour and leadership that Indigenous claimants bring to climate cases. This is a significant legal opening and one we cannot afford to overlook. We're also seeing that Indigenous worldviews and knowledge enter the common law in new ways. Cases that allow evidence to be heard on country, or judges who are willing to learn from plural legal sources, are helping expand that the law can hold. At the same time, it's clear that legal strategies can't be separated from the political struggles that sit within. Struggles against structural inequality, extractive capitalism, and the ongoing suppression of Indigenous sovereignties, reasserting Indigenous land relationships and economic and cultural sovereignty. It is not optional, it's central to the work of climate justice. We are also seeing the power of strong community-led campaigns that surround right-based climate litigation. They build the democratic legitimacy and the public pressures that can drive both legislative and judicial change. And finally, within a strategic climate litigation framework, the aim isn't only to win norms and move the broader project of social change forward. These cases show us that litigation is one of the part of a much bigger movement. And the courtroom can be the place where the movement gathers strength. I want to acknowledge the words of the Aboriginal activist group in Queensland in the 1970s, whose words speak powerfully to the heart of this work. If you've come here to help me, you are wasting your time. But if you have come here because your liberation is bound up with mine, then let us work together. For me, this captures the essence of climate litigation. As a matter of Indigenous rights, it's not about charity or coming to save communities. It's about solidarity and shared responsibility. Recognising that the right to a safe climate, to health, to culture and to home are fundamental human rights. Because the struggle of climate justice is, at its heart, a struggle for Indigenous rights. And in standing for those rights, we created conditions for a healthier, more just and more livable world for all of us. Our fight for country is a fight for rights, for health and for all of our futures. Our health, our cultures and our futures are interconnected, and we can only face the challenges of climate change if we walk together. I put up here some work that I have completed looking at Indigenous-led rights-based approaches to climate litigation. An international scoping review drawing on communities throughout the world in the fight for justice through court systems. It's worth a read, it gives an insight. I do 4 case studies on drawing from. But as I went back to the UNDRIP and the Morrison government and the Torres Strait 8, drawing from an international framework, UNDRIP, United Nations Declarations for Indigenous People, it was recognised but it didn't stand. It wasn't in our constitution. Why do we have to abide by it? That just shut down. But maybe it's telling me to get going. But we've got to think about this. When we're thinking about challenging systems, when we think about, we've got to see what those gears are, what are the mechanisms, and we really have to put in a crowbar. Think bigger than what you're faced with, because these fights, as you can see, the Mabo case, the Strait 8, the current case, these are long drawn out cases. So people don't want to take them on, people think they're too complex, but if we do nothing about it, then we're facing the same thing. In my language, in closing, a very big thank you for all in here and online, taking the time to listen. Ki meso, big thank you.